talk about the Seminole Tribe v. Florida 1996 Supreme Court decision. This is a court case that's in a series of court cases that, after the Hans decision, Hans v. Louisiana decision, you're just going to have a clusterfuck of cases. Hans v. Louisiana assumes state sovereignty comes from the 11th Amendment, which it doesn't, but after the Supreme Court had announced it, then they've been carrying the doctrine of sovereign immunity on since 1890. So it's not in the 11th Amendment. The 11th Amendment was half wrong in 1798 when it was passed, but after the Hans decision in 1890, it was 100% wrong. Then you're going to have the Alden v. Maine decision. That's a horrible one where they didn't enforce the Fair Labor Standards Act. They said the legislature, the national government, doesn't have the power to sue the states. They messed up several times. They have some exemptions, so essentially the states have sovereign immunity, except when the federal government was to enforce the 14th Amendment, or whenever the federal government was to enforce the Commerce Clause. Those are two exceptions to the sovereign immunity rule, but when it comes to the Fair Labor Standards Act, or when it comes to the Indian Gaming Regulatory Act, which both are passed by Congress, signed by the President, both the legislature and the executive believe in it, but it was too much for Rehnquist and SCOTUS in 1996. So Congress could pass the Indian Gaming Regulatory Act. They could pass the other thing, the Fair Labor Standards Act. But Congress says because of state immunity, the Indian Gaming Regulatory Act is therefore unconstitutional, and then also so is the Fair Labor Standards Act, or the way they were enforcing it was unconstitutional. So Commerce Clause, okay. 14th Amendment, fine. Fair Labor Standards Act, nope. Indian Gaming Regulatory Act, nope. So what's going to happen in the Seminole Tribe of Florida v. Florida, 1996, they're going to say, well, Florida's a sovereign immunity. They have sovereign immunity, so therefore the Seminole Tribe can't sue them, even though the law, the Indian Gaming Regulatory Act, very specifically said that they could. So this is major. If you are preventing Article 1 of the U.S. Constitution, the power of the U.S. Congress from being able to abrogate sovereign immunity, which is protected under the 11th Amendment. It's not. They misinterpret that, and they've just been misinterpreting it for the last 100 years. The whole point of putting the congressional powers under Article 1 was to say that the legislature was the most powerful of all three branches. So it's just crazy that the Supreme Court is coming in here saying, nope, we don't care about the power of Congress and the President. So this principle of the power of Congress, spelled out in Article 1, because it's the most powerful branch of government, is not upheld in the 1999 Alden v. Maine SCOTUS case. So for both of those cases, for whatever reason, commerce and the 14th Amendment, that can, that breaks sovereign immunity, but the laws. Okay, so let's talk about specifically this 1988 law. Okay, so this is 1988 Congress. It's either the last year of Ronald Reagan or the first year of Daddy Bush. So some Republican president passes the Indian Gaming Regulatory Act, and this is a statute which requires the states to negotiate with Native American tribes to create compacts governing Native American casinos, gaming. The statute provided that if a state failed to enter into such negotiations or to negotiate in good faith, the tribes could sue the state in federal court in order to compel the states to negotiate. If the state still refused, the statute provided that the matter would ultimately be referred to the Secretary of the Interior. Congress had asserted its power under the part of the Commerce Clause relating to commerce with the Native Americans to pass such a statute, abrogating the immunity of states pursuant to its express powers. The Seminole Tribe of Florida, that's another thing. Yeah, Article 1 expressly says this is the power. Sovereign immunity is nowhere in the Constitution. It's implied. It's not an express power. So the Seminole Tribe of Florida, they complied with the law. They wanted to negotiate with the state of Florida in order to start, having some conversations to get gaming, right? They're trying to talk about gaming, who's got this right, who's got this right. The Seminole tribe tried to do what the Indian Gaming Regulatory Act required them to do. The state of Florida didn't negotiate with them, so they went ahead and kicked it, you know, into overdrive, right? So they requested the state to, you know, enter into a negotiation as the Indian Gaming Regulatory Act had required. State of Florida says, no, fuck you, Seminole tribe. We will never negotiate with you in good faith, you pieces of shit. And so the Seminole tribe filed suit as allowed by the statute against both the state of Florida and the governor, Lawton Childs. The district court declined to dismiss the case, but the United States Court of Appeals for the 11th Circuit reversed, holding that the 11th Amendment barred the suit and that the doctrine of ex parte Young cannot be used to force good faith negotiation. So the doctrine of ex parte Young, this is 1908 Supreme Court decision. It's the doctrine that the citizens of any state can sue any state just so long as they sue their specific public officials in their individual capacities and not sue the state itself. You can't sue the state itself, but you can sue its officials. That's the doctrine of ex parte Young. They had created a loophole against sovereign immunity. But they're saying that this doctrine didn't apply when forcing specific public officials of Florida to force them into good faith negotiations with the Seminole tribe. So what a total crock of shit. The original meaning of the 11th Amendment has been so mangled and jangled. The legalese of the Supreme Court currently, when it comes to the 11th Amendment, is just one big-ass clusterfuck. I mean, haven't the Native Americans been through enough? All they wanted, all the Seminole Native Americans wanted, was good faith negotiations. You know how low that bar is? Good faith negotiations. You could have good faith negotiations almost with anybody. And this is something that needed to be talked about. So when it comes to, does the power of the U.S. government, do they have the power to force the Seminole tribe in the state of Florida to sit down at the table for good faith negotiations? Yes. Yes, they do. The U.S. Congress, the American government has the Supremacy Clause, the General Welfare Clause, the Necessary and Proper Clause. So the United States government can do whatever is necessary and proper it needs to do in order to protect the general welfare of the people, including Native Americans, including the Seminoles, including the people of the state of Florida. So what is necessary and proper to protect the general welfare of the people is protected by the U.S. Constitution. Of course, the U.S. federal government can force good faith negotiations. That's such a vague term, good faith. So as long as you try, that's good faith. As long as you go in there, you know, not trying to fuck them over, in good faith, you want to sit down, you have interest, they have interest, and so, you know, can a deal be made? Just sit down at the table, see if a deal could be made. If it can't, then walk away. That's good faith. You tried, right? Did you try? Okay, that's good faith. They didn't require them to resolve the conflict. They just said you had to sit down at the table and you had to have, you know, you had to knock that chip off your shoulder. So 1996 SCOTUS decision is absolutely wrong. The threshold of meeting good faith is so low a bar only an asshole or criminal would oppose. So 1996, this is fucking William Rehnquist. And again, fucking legal shenanigans are fucking over the Native Americans, the Seminoles, the Seminole tribe of Florida. So this is given sovereign immunity, just keeps on getting bigger and bigger, right? These people in government keep on saying they have sovereign immunity. So the Supreme Court goes ahead, passes sovereign immunity to the executive and legislative branches. Just pass it around, right? This immunity is some good crack to the people in power, right? You're immune, he's immune, we're all immune. Who gives a shit? Let's commit crimes. So the Supreme Court now was to decide, okay, what is to happen? All right, when it comes to the Indian Gaming Regulatory Act, can the Seminole tribe, they did what they're supposed to, state of Florida refused, so they used the mechanism in the law that Congress passed, and now what's William Rehnquist? What's he going to say? Well, he says it's unconstitutional. The doctrine of Ex parte Young doesn't apply. So the loophole to sue the state officials, you can't use that loophole. The whole thing's unconstitutional. He says the 11th Amendment had further protected the state's sovereign immunity. 14th Amendment placed limitations on the 11th Amendment, but only with respect to the rights guaranteed in the 14th Amendment. This is William Rehnquist. He's really taken the Hans v. Louisiana decision. He's ignoring there's two good court cases in the very beginning. The very first court case, Chisholm v. Georgia, 1793, and Cohens v. Virginia, 1821. That both of those were great court cases that got it right. So if we got to use the process of stare decisis, well, you got two court cases that are earlier than the Hans decision. Cohens v. Virginia, Chisholm v. Georgia. Chisholm v. Georgia says that the people of South Carolina can sue the state of Georgia to get their money back. And then the Cohens v. Virginia decision said that the citizens of Virginia is allowed to sue Virginia after the 11th Amendment was passed. So we still had a right to sue our own state in 1821. We lost that right as Americans in 1890. And ever since then, they just keep on, this whole clusterfuck, this crazy-ass clusterfuck. Once they assumed sovereign immunity, a big-ass power that they don't have, well, they just threw a big-ass, monkey wrench into the machine. So they're saying that the 11th Amendment protects state sovereign immunity. The 14th Amendment has some limitations on the 11th Amendment, but not much. The court also found that the doctrine of ex parte didn't apply. They invoked the rationale of an earlier case in Schweiker v. Chilicki. So in the Schweiker v. Chilicki case of 1988, they said that the proposition that where Congress had provided a remedial scheme, the courts would not apply the existence of additional remedies. So therefore, since the law, Indian Gaming Regulatory Act, said that they had to sit down for good faith negotiations, and then if they didn't do it, then you were supposed to sue them. Also, the Secretary of the Interior would be notified. So they passed this law, the Indian Gaming Regulatory Act, but because they specifically mentioned a remedy, which they're now saying is unconstitutional, they only specifically said one remedy, and they said that remedy is now unconstitutional, therefore they have no more remedies left. Which is absolutely insane. Now you're going to have David Souter's dissent in the 1999 Alden v. Maine decision, which is very instructive. So the Cohens v. Virginia decision of 1821 is a good case when it comes to the 11th Amendment to build up your case against sovereign immunity. And then also the Chisholm decision, which ultimately, shows that the 11th Amendment is bullshit because Chisholm was right. The state of Georgia owed Chisholm money, so pay Chisholm his damn money. Jesus Christ, he had to sue a whole state and then go to the Supreme Court. I'm sure that wasn't easy. So Justice David Souter's dissent in the 1999 Alden v. Maine decision is also wonderful, too. So in his response to the proposition that Congress, if they provide a remedial scheme in their law, then the courts would not imply the existence of any additional remedies. Well, they said, if A happens, then B must happen. They didn't say C, D, or E. And since B is unconstitutional, I guess you don't have a law. I guess you can't enforce your law. So Justice David Souter disagrees with the court's rejection of Ex parte Young. He said that where the Chilicki decision, Schweiker v. Chilicki, he said that the rejection of the extra statutory remedy proposed, Young, was merely a jurisdictional device. So what? Wait, I thought there was, essentially he was saying that just because the Congress wanted to see their statute, he said, hold on, let me get this right. Okay, so the Congress says that the Indian Gaming Regulatory Act needs to be remedied by suing the state to force good faith negotiations. You could go to the Department of Interior, then you go, if they don't do it that way, you got to sue them. So Young was a jurisdictional device. So we're Chilicki, okay, so, all right. Get it together. So they're saying because the Indian Gaming Regulatory Act had one remedy, that remedy was unconstitutional, therefore Congress doesn't want their law to get passed. So Justice David Souter says it's implausible that Congress would wish to see their statute made completely unenforceable simply because they had included a remedy for those injured by the failure of states to abide by it. Oh, that's it, right? We provided a remedy. You said it's unconstitutional, so just throw the whole law out. There's no remedies even allowed. So it's unenforceable because they included a remedy. If they didn't include a remedy, then you could choose the remedy. But they included the remedy, so therefore no other remedies are allowed. So he's, absolutely right about that. Suing the state officials isn't allowed because the Indian Gaming Regulatory Act only said they could sue the state itself, which was unconstitutional, therefore it's unenforceable. The whole fucking law needs to be thrown out. So the dissent from Alden v. Maine, 1999, David Souter, he's a genius. He's very smart. He said that it was a 4-justice dissent. So 4 justices were opposed. 5-4 split decision, Alden v. Maine, 1999. David Souter said that the states surrendered their sovereign immunity when they ratified the Constitution. You joined as a union of states. You joined the United States of America, so you gave up sovereign immunity when you did that because the federal government has to enforce the laws somehow. Justice David Souter also notes that Congress had rejected proposed language for the 11th Amendment, which clearly would have clearly barred suits between states and their own citizens, and which would clearly have prevented Congress from abrogating this bar. So that means when they were deciding for the 11th Amendment, they said, okay, we're going to go ahead and ban the states of other states, or we're going to ban citizens of other states, we're going to ban citizens of other countries from suing the state of Colorado, and we're going to ban the citizens of the state of Colorado. No. So they all objected to citizens not being allowed to sue their own state. The legislature did. This is Caleb Strong, the guy who introduces the 11th Amendment. So they rejected that language. They cut that language out. So the 11th Amendment bars citizens of other states and other countries from suing your state and allows the citizens of their own state to sue the state. It leans towards sovereign immunity, but when it comes to your own citizens, you can't have sovereign immunity. Sovereign immunity applies to everybody else that's outside the state. None of the citizens outside the state can sue the state. So therefore, they have sovereign immunity in that respects. But the 11th Amendment is very clear until the Hans decision. And then after the Hans decision, we've just been in cluster fucktown. So I'm sure William Rehnquist thought he was making the correct decision. Well, I'm a thoughtful person, and I listen to the arguments, and but he's wrong. He's absolutely wrong in this. He fucks over the Seminole Indians, the Seminole natives of Florida, just because of some fucking bullshit legal shenanigans, some technicality. So who was right? Right? Seminole tribe tried to sit down with the state of Florida. The state of Florida were being a bunch of, valley girls, stuck up, pretentious, snobby valley girls, didn't want to sit down to talk, and therefore we're going to go ahead and side with the state of Florida. They didn't even want to do good faith negotiations. No, we will sit down and we will be very antagonistic and combative. When we sit down, we will be antagonistic and combative, and that's just the way it is. Oh, yeah, fantastic. So it was such a low bar for them to, agree to, and the fact that they couldn't even do it, that's so fucked up. That's so fucked up. Congress passed it. It's hard for Congress to pass these laws, and then the Supreme Court just chucks the whole thing out. Why? I guess the state of Florida had, bottomless pockets so they could spend, shit ton of money for high-priced lawyers, and then they come up with a bunch of fucking legal shit that eventually the Supreme Court agrees with. And ultimately, the Seminole tribe gets fucked over yet once again. Haven't we fucked over the Native Americans enough? The U.S. government can force good faith negotiations because they have the necessary and proper powers to enforce whatever is best for the general welfare of the people. So the Seminole 1999 Seminole Tribe v. Florida case is absolutely wrong. Fucking Rehnquist is bullshit. So fuck you, William Rehnquist. Fuck the 11th Amendment. Fuck the whole concept of sovereign immunity. God damn it. And quit fucking over the Seminoles. Jesus Christ.